I rise to add to the debate in relation to the bill entitled Criminal Records Rehabilitation of Offenders Amendment Bill. See, Madam Speaker, I'm sure you are aware that prior to coming to here, I would have practiced as a defense attorney.
One of the best.
Indeed. I see.
Another one.
And I see Justice Lands here, and I would have appeared before her. Of course, not in the criminal court, but my practice would have, on that sojourn, I would have represented a number of persons who would have gone before the courts specifically for drug-related offenses. This amendment specifically speaks, however, to persons convicted in relation to the cultivation of a certain amount of plants. Now, I think some members may be trying to suggest that this step taken by the government isn't, a big thing. If I can just refer to the data, and this is from the Royal St. Kitts and Nevis Police Force. The controlled drug statistics, particularly for the cultivation of controlled drugs. 2010, 17 convictions. 2011, 29 convictions. 2012, 24 convictions. 2013, 14. 2014, 17. And it goes on as recent, I think in 2021, there were no convictions. In 2022, there were 6 convictions. Madam Speaker, that is because the court's approach in relation to convictions for these types of offenses, particularly cultivation, possession, and not so much supplying, the court had taken a relaxed approach towards these types of offenses. And that, of course, is in keeping with the decriminalization of cannabis. I don't want to say marijuana. Now, what is a little disingenuous is when the honorable member from number 5 suggested that as much as he is not against the amendment, he thinks that the substantive legislation that addresses the criminalization of the cultivation of cannabis should have come first. When the honorable member, beg your pardon? But he's saying it should be in sync. I took it to mean that they should have come together, or it should have come first. In any event, what is a little disingenuous to me is that the same case that the honorable member from number 8 made reference to when the amendment was introduced, the Sankofa case. The court in that case directed that by a particular time, the matter was to have gone to Parliament for Parliament to make rulings on it. I think the particular time was 3 months, 90 days to be exact. We were not sitting where we're sitting now at that time. That didn't happen. The matters, this takes me back, Madam Speaker, to the statistics. Because notwithstanding the court's ruling in that case, matters continue to be brought before the court by the police officers. The court could not make decisions because these decisions stood and were subject to appeals before the same court that made the ruling. And so that might account for the zero that is reflected, I think, in 2021 in terms of convictions for these types of, for offenses, particularly related to cultivation. And so I want to support the amendment. I want to support the bill on that basis. The other reason, Madam Speaker, why I rise to support the bill, now, similarly to what the Honourable member from number 8 said, I remember a few months ago when I was canvassing a particular area called Dilil Gardens, thank you. I encountered not a young man, an elderly Rastaman living in poverty. I spoke to him and he said his entire family lives in the US. He was going to get his papers, as we like to say, and he couldn't because he had a record for cultivating cannabis. And that stayed with me. And that was just one of the many cases. In court, I've seen a number of persons convicted for this type of offense. And so I think the introduction to the bill is indeed a step in the right direction. We will do what needs to be done to push the agenda forward in relation to the rehabilitation of offenders, as well as in relation to decriminalizing the offenses related to drugs, as the High Court would have ruled, I think, some years ago. And so, not to add to what everybody has said in terms of what criminal records do in terms of preventing you from getting jobs and visas, but to speak to what the Honourable member for number 5 said, and to speak to what the Honourable member from Nevis 11 says in terms of the intent of the legislation. The intent is really just to deal, as the substantive legislation says, the purpose is to provide for certain criminal offences to be spent and be expunged from the police criminal records of the persons who become rehabilitated. Now, what this means, if you're convicted, you're still going to be punished. So this isn't going to act as a means for people to continue to plant. If you're convicted, until it's decriminalized, if you commit the offense, you're going to be convicted. So this doesn't, I'm not sure what the member from number 11, the Honourable member, was suggesting, but the intent is to make your criminal record spent. It means then you will have a criminal record if you are convicted. There's still steps that need to be taken in terms of decriminalizing it, and those steps would be taken shortly, I'm told. And so I rise. Like I said, I just want to support the amendment and wish it safe passage through this Honourable House. May it please you.